I want to tell you about her before I tell you about the case, because by the time most people hear about cases like this one, the person at the center of it has already become a number in a file. She was not a number to me. She never was. I am beginning there because the silence at the end only makes sense if you understand who was standing in front of me when that silence arrived. I can still hear it. A room full of people and then no sound at all. Subscribe. Not for me. For the reason I am telling this. Some stories need more people to carry them than were in the room when they happened. Subscribe and help me carry this one. When Marisol Vega walked into my courtroom, she held a blue plastic folder against her chest with both hands, not tightly, but carefully, the way people hold the few papers that stand between them and chaos. She was 32 years old. She worked the early laundry shift at East Bay Linen Services. She was raising her daughter Lucia on her own. What I noticed first was how little space she seemed willing to take from the room. There was one small thing she did that I have not forgotten. She sat down, opened the folder, found a pharmacy receipt, smoothed it flat with the side of her hand, and then tucked a purple school hair clip into the corner pocket, as if she had found it at the bottom of her bag and could not afford to lose one more thing that day. I have sat across from many people. Small movements tell me a great deal. That one told me she was already carrying more than the file could hold. Everett Lang came in a few minutes later with counsel. He was 46, a real estate developer, wealthy enough that his name opened doors before he reached them. He did not look at Marisol when he entered. He looked at the gallery, then the clock, then his watch, and only after that did he look toward the bench. That order mattered to me. People reveal where they believe consequence lives. There was one human thing about him that morning. Marisol mentioned her daughter's age during a pre-trial exchange, and I saw him turn his wedding ring once with his thumb and look down for half a second. It did not excuse him. It made the whole matter worse. It told me he understood enough to know what a child in the back seat meant. He simply chose not to let that understanding govern him. The incident happened on Tuesday, January 14, 2025 at 8:12 a.m. in the parking lot behind Harbor View Pharmacy on Westminster Street in Providence. I know that because the time appeared in the security footage, the pharmacy receipt, and the police log. Marisol had picked up Lucia's inhaler. She still had to get her daughter to school and get herself to work by 9 p.m. Everett Lang arrived in a black Mercedes G-Class and stopped his vehicle behind Marisol's 2011 Toyota Corolla. At first, it looked like impatience. Then it became something else. He had room to move. He chose not to. When Marisol tried to angle out, he stepped from his SUV, held up one hand, and left the vehicle where it was. The delivery driver heard the first words. The cashier heard more. And later, under oath, the wording was repeated with no real dispute. Marisol said she needed to leave. Everett Lang said, "I pay more in property tax than you make in a year. You can wait." He said it quietly. He did not need volume. His car was doing the louder part. She said she asked him again and again to move. The driver said it was 4 times. The audio on the camera was poor, but the body language was not. Her hand came out the window once, then twice. At 8:19, Lucia cracked open the back door. Marisol pulled it shut from inside. At 8:27, Everett moved his SUV forward another 1.5 feet, not away, closer. A witness said he heard Everett say one more thing. He said, "If you can't manage a child and a schedule, that is not my emergency." That sentence stayed with me because it reduced 2 ordinary burdens of adult life into a reason to dismiss her. Not because he could not help, because he did not believe he had to. I want to ask you to subscribe before I go further. And I want you to know that I do not ask lightly. What comes next in this story is the part that cost me the most to say out loud. Subscribe. Stay with it. What reached my desk first was paperwork. Charges for reckless use of a vehicle to intimidate, disorderly conduct, and unlawful obstruction of passage. A civil claim for lost wages, a counseling intake bill for Lucia, transportation costs, and school late penalties. Paper has a way of flattening people. It lists what can be counted and leaves the rest outside the margin. There is a detail most people do not know about cases like this. A phone video is not evidence just because everyone has seen it. Someone has to testify when it was taken, where they were standing, whether it fairly shows what happened, and whether it has been altered. I have always believed the law should be explained in plain language. If I am going to rely on proof, I need to know who carried it into the room and how it got there. The moment in the process that made me pause was a single line in the file. Obstruction duration, 41 minutes. The law can name minutes. It can name distance between vehicles. It can name whether there was contact and whether a threat was spoken. What it cannot fully name is what it means for a mother on hourly pay to watch 41 minutes disappear while her child asks from the back seat if they did something wrong. I could decide what the law would do. I could not give her back those 41 minutes. There were 3 silences in that courtroom, not the ordinary quiet between one answer and the next. I mean the kind that settles when something true enters the room and nobody wants to be the first person to make noise after it arrives. I have carried those 3 silences longer than I carried the case file. I am going to tell you about all 3. From the bench, entrances matter. Marisol came in first on trial day, wearing a navy coat with one loose cuff button. She kept the blue folder close to her body the whole walk to counsel table. The thing only I could really see from where I sat was that she never once turned her full body toward Everett Lang, even when she knew exactly where he was. She gave him only side vision. Sometimes that is how people keep themselves intact. Everett Lang entered through the main doors with his attorney and an assistant carrying a thin leather case. He placed his keys on the table, moved them, then moved them again so the car emblem faced upward. That was not evidence. It was simply something I saw. He watched the gallery more than he watched the witness stand. He wanted to know who would witness his inconvenience. Silence 1 came when Marisol spoke in her own voice about what she had asked for that morning. Her attorney had covered the ordinary points: her name, her work, her daughter's age, the time she had left the pharmacy. Then he asked what she had said to Everett Lang when he would not move. She looked at me, not at her lawyer, and said, "I was not asking him for kindness. I was asking him to let me leave." The room went still for about 9 seconds. The clerk's fingers stayed above the keyboard. The bailiff near the back door shifted his weight and then stopped. Nobody broke that silence right away. Marisol did. She swallowed, put both hands on the rail, and waited for the next question. After silence 1, I understood something the file had not allowed me to understand. This was not a parking dispute. It was not an argument that got out of hand. It was one person deciding that another person's time, work, and child could be held in place until he felt done with them. The first wave of evidence came in cleanly after that. The pharmacy cashier confirmed the inhaler purchase at 8:16 a.m. The school attendance record showed Lucia marked late at 9:07. Payroll records showed Marisol lost 1.2 hours of wages, $21.84 after rounding, though the real cost was larger because missing part of the breakfast shift affected the following week's schedule. The delivery driver said he watched Everett move his SUV twice and said he was not trying to sort it out, he was settled. I wrote that sentence down in my own hand. He was settled. It was not dramatic, and that is why I trusted it. People who are confused move around uncertainty. People who are settled in their own rank can stand very still while someone else pays for it. We had still photos from the lot camera at 8:20, 8:28, and 8:34. I remember them because they looked almost the same until you studied the angle of the tires and the narrowing space behind Marisol's rear bumper. In the last frame, Lucia's face was visible in the back window, turned forward, waiting. Marisol said one more thing in testimony that morning. She said, "My daughter asked me if rich people can make you stay." Children sometimes ask questions larger than their own years. That was one of them. I said nothing because my task at that moment was to keep the room steady. But I heard it, and I have heard it since. Cross-examination was careful. Defense counsel did what good counsel must do. He asked if Marisol raised her voice. She said yes. He asked whether Everett touched her. She said no. He asked whether she could have driven over the curb and around a delivery van. She said, "I was not going to climb a curb with my child in the car," because a man with money wanted me to solve the problem he was making. Subscribe before I go further. I have more to tell, and the more I tell, the more it matters that someone is listening. Subscribe and turn on notifications, then let me continue. The defense rested much of its case on intent. They said Everett Lang had been rude, impatient, and proud, but not criminally intimidating. They said private lots create confusion. They said he believed Marisol might have brushed his mirror. They said no collision occurred, no physical contact was made, and no direct statement of, "You may not leave," was spoken. I listened to all of it, and I will tell you plainly that one point gave me pause. Counsel argued that on the first movement of the SUV, Everett might have believed he was making room for a delivery truck rather than tightening the space behind Marisol. On the still photo alone, without sequence, that argument had shape. When placed beside the timing, the witness accounts, and the second movement of the SUV, it lost it. Then Everett Lang took the stand. He wore a gray suit, no tie, and spoke in the calm voice some people use when they believe calm itself should be credited in their favor. He said he never intended to frighten anyone. He said he was protecting property. He said, "I never touched her, so I do not see how she can say I trapped her." That was the quiet kind of wrong. A vehicle does not need to touch your body to tell you that you may not leave. Later, when his attorney asked why he did not move once he understood there was a child in the car, Everett said, "I assumed she could call someone. I wrote it down. I looked at it for a long time before I moved on to the next page. There are sentences that reveal a life without meaning to. Hidden inside that one was a whole way of seeing the world. Help is always one phone call away. Delay is manageable if it belongs to someone else. Need is an inconvenience when it arrives in the voice of a person you do not rank as equal." He tried once more to sound reasonable. He said, "I was under pressure that morning. Investors were waiting, and I did not have room to manage her emotions." He thought that sentence would make him sound burdened. What it told me was that he had mistaken her urgency for a performance she was staging in his way. Silence. 2 came at the end of his testimony. His lawyer asked if there was anything else he wanted the court to understand. Everett straightened one page, looked toward me, and said, "I did not think missing one shift would matter that much." Then he stopped. That silence lasted 7 seconds, and it did not feel like the first one. Silence 1 felt like a room receiving pain. Silence 2 felt like a room recognizing contempt after trying very hard not to name it too early. The court reporter kept her hands on the machine. The clerk looked down. Even the air vent sounded sharper to me. That was the moment my understanding of the case stopped moving. Not because the law had become simple, because the truth had become plain. He had arranged his thinking so that another person's wages looked small because they were not his wages, another person's child's fear looked manageable because it was not his child, and another person's day looked disposable because he had enough money to imagine time can always be repaired later. Subscribe. I am not going to make a case for it. You are already in this story. Subscribe and let me finish it. There is a memory from my own life that returned while I listened to all of this. I did not call it in. It came on its own. I was a boy, maybe 10, standing in a dark kitchen before sunrise. My mother had one hand around a coffee cup she did not have time to drink from. With the other, she was counting bills twice before folding them into a tea tin. On the chair beside her was a paper bag with a sandwich inside and an ironed blouse laid across the back so it would not wrinkle before work. I place that memory here because that is where it sat in me while the testimony went on. I did not speak it in court. I simply carried it and kept listening. By the time counsel finished closing, I had already begun to feel the edge of silence 3 approaching. From the bench, there are moments when a room has not yet heard a sentence but has begun preparing itself to absorb one. I had made my decision carefully. I had made it knowing that careful decisions and right decisions are not always the same thing, and believing that in this case they were. I found Everett Lang guilty on all 3 counts before me: reckless use of a motor vehicle to intimidate, disorderly conduct, and unlawful obstruction of passage. Marisol lowered her head once and let out a breath through her nose. Everett's assistant, seated behind counsel, reached for a pen, missed it, and then folded both hands in her lap. I have not told you what I ordered yet. I am about to. Subscribe before I do, not because it is dramatic, but because I want to explain every part of it, and I want you to be here for the explanation. Subscribe now. Before I gave the sentence, the room was already close to stillness. The clerk held a file with both hands. Defense counsel leaned back only half an inch, as if even space had become careful. I looked at Marisol. I looked at Everett Lang. Then I looked back at the written order so nothing in it would be careless. I said, Mr. Lang, I am ordering you to pay a fine of $15,000 to the Rhode Island Single Parent Transportation Fund. Then I explained why in plain terms. You used delay as a weapon against a mother whose day was already measured by work, school, and medicine. Money was part of the imbalance you leaned on. This payment goes to a cause tied directly to the kind of harm you treated as small. I said, I am also ordering the suspension of your operator's license for 180 days. Then I told him what that meant. For the next 6 months, you do not get to sit behind the wheel and decide with a machine in your hands who waits and who moves. Driving is not a private expression of mood, it is a public trust. I said, I am ordering 240 hours of community service at the South Providence Family Resource Center, specifically in morning intake, transportation coordination, and school arrival support. I chose those details for a reason. Not hidden hours, not any placement. I want you in the part of the day where 10 minutes matters, where one missed bus or one delayed ride can break 5 things before noon. Then I said, and there is one more thing. The room became even more still. Within 30 days, you will appear at the South Providence Family Resource Center on a Saturday morning in the presence of staff and any parents who choose to remain, and you will read aloud a written apology approved by this court. You will also provide signed copies for the court file and for Ms. Vega if she chooses to receive one. Then I told him why. What you did was public. Repair, if it means anything, must also be public. I was not finished. You will also pay restitution in the amount of $8,214.33 to Marisol Vega. I read the numbers into the record. Lost wages, counseling for Lucia, replacement transportation, school penalties, and the child therapist intake fee. Marisol paid 2 weeks later, when Lucia began asking if men in large cars were allowed to stop them. Then I said, this is not generosity, it is debt. After that, I spoke directly to him. I said, what you did cost money. It also cost order inside a child, and that does not return just because the court says so. Your family did not stand trial here today, and I will not speak to them as though they did. But I will say this to you. A man in your position is given many chances to make room for other people, and on that morning you chose instead to make a smaller room around one woman because you could. Then I said, you treated her schedule as if it did not count because it was built from hourly pay, school check-in, and a medicine pickup instead of investor calls and property meetings. The law does not recognize that ranking, neither do I. And I ended where I believed the moment belonged. The person this court is thinking about today is Marisol Vega. Silence. 3 began when I stopped speaking. It lasted 14 seconds. No paper moved, no chair shifted. I heard a bracelet tap, once against the wooden rail, and then stop. From the bench, silence has a physical form. You see it in shoulders that do not drop yet, in faces that remain fixed, because nobody wants to be the first person to make sound after something permanent has been spoken. When the silence finally broke, it broke small. The bailiff took one careful step toward the aisle. Everett Lang looked down at his hands. Marisol did not look at him. She kept her eyes on the witness rail as if she needed to be sure the wood in front of her was real. Thank you for staying with this. I mean it in the specific way you mean something when it costs you something to say. Subscribe if you have not yet. You already know why you are still here. I was still seated when the courtroom began to empty. The first thing Marisol did was take the purple hair clip from the blue folder and place it in her coat pocket. Then she turned to the woman beside her, her sister Elena, and said softly enough that only those near the bench could hear, "Tonight I get to tell Lucia the law heard us." I have said that sentence back to myself more than once since the case closed. Everett Lang remained at counsel table longer than most defendants do. His attorney leaned toward him and spoke quietly. His assistant picked up the leather case, then set it back down, as if her hands had lost the next instruction. When I finally stood, the room was almost empty, and his water glass was still full. The appeal was filed 17 days later in Rhode Island Superior Court. It was heard that fall. On November 18, 2025, the court affirmed the findings and left the license suspension, restitution, and service requirements in place. In plain language, the appellate ruling said the evidence supported my conclusion that a vehicle had been used to confine and intimidate without physical contact, and that the sentence matched the conduct proven at trial. The process took just over 10 months. My response was simple. I read the opinion at my desk, set it down, and called the next case. Months later, I learned one more thing. On May 14, 2026, the director of the South Providence Family Resource Center wrote to the court that Everett Lang had arrived for his intake shift at 7:25 a.m., a year before the doors opened, and spent his first 10 minutes carrying folded strollers from the donation room to the front hall without being asked. I am not telling you what that means. I am telling you what happened. The question this case left with me is not whether punishment matters. It does. The question is how early contempt begins. Does it begin in the sentence spoken aloud, or much earlier, in the daily habit of believing another person's time can be taken because you can afford your own? I do not know the full answer to that. I still think about it. What I do know is that the law often meets people late. By the time they stand in front of me, a great deal has already been practiced, permitted, and mistaken for normal. A parking lot is never only a parking lot if one person enters it already convinced that convenience belongs to them more than it belongs to the next person. I have learned that grief and clarity are not opposites. If you sit with one long enough, it often gives you the other. So let me speak directly to the people who know something of Marisol's face from the inside. I recognized in her an expression I have seen many times. It is the look of someone arranging facts carefully because they expect disbelief before they even begin. If that lives in you, if you have ever had to make your truth sound calm enough to be accepted, then you know how tiring that is. I saw it. I did not miss it. And to the people who have more room, more ease, more habit of assuming the day will open when they press on it, I want to ask the question I could not ask from the bench because it was not a legal question. When did you decide another person's delay was smaller than your irritation? Before you answer, spend one full morning carrying a child, a work clock, medicine, and the fear of missing any one of them. Then speak. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And if you speak in the comments, speak the way people do when they understand something hard and want to leave the room a little gentler than they found it.